Hi everyone. I've done a couple of videos addressing sourcing of property sourcing, or with the American context, we're looking at wholesaling. Also did a video where I drew distinctions between sourcing and back-to-back agreements. So now just briefly moving on to back-to-back agreements and having a conversation around what the requirements are to do a back-to-back. So just to kind of touch on this briefly and echo what I've mentioned in previous videos, a back-to-back is not property sourcing in the strictest sense because you are buying the property and selling the property onto somebody else. So it's two sale agreements, which is totally allowed. You don't need to be registered with the Estate Agency Affairs Board to follow this process. So even though it mimics sourcing, it is not strictly speaking sourcing because you are just buying and selling an item from one person to another person. Also, as explained in previous videos, there's certain transfer duty issues that you may need to look out for, conveyancing fees that need to be paid, but I do touch briefly on little hacks in order to be able to deal with these. So now let's assume that we're happy pursuing a back-to-back sales strategy, that we're happy with the profit that we're going to make on buying for a lower price and selling for a higher price. And our question is now around how do we go about doing this? Now, as I explained previously, a back-to-back transaction simply involves two sale agreements. Now, so the only differences that one would be looking at when dealing with these sale agreements is the fact that when you're buying the property from one person, you need to cater or cover yourself for a number of situations. So, for starters, some contracts I find may contain a provision saying that you're not allowed to sell this property onto anybody else until you've taken transfer. So, there's some prohibitive clauses. Which I find mostly are in contracts involving banks, but your normal private contract wouldn't have this. And you are allowed to sell the right. So you're not selling the property, you're selling the right to a property. So when you buy, you're allowed to make the offer. Then when you sell, that I feel is when it's very important to make it very, very express to the purchaser, to whoever you're selling to, that you have not yet taken transfer, you are not yet owner. The contract that you're entering into is subject to you becoming owner and taking transfer, and only at that point would become effective. That the process can start in the meantime, and certain provisions would survive. So typically what we suggest that you do is you run through all the time periods, because with the back-to-back, what you want to achieve is that transfer takes place at the exact same time as the first transaction. So when you're buying from this gentleman, taking it into your own name and selling it on to somebody else, you want all of this to be registered at the deeds office at the same time. So the first contract is not where your problem is. That's a normal contract. Your second contract is when you want to express and say, well, the second transfer has to be subject to the first transfer. We start running with the time period. So we want your deposit, we want your guarantees, we want everything to happen perfectly on time, because we want to be able to lodge everything at the same time. But please note that you can't hold me to this, because if anything goes wrong with the first transaction, you will not become owner and you cannot enforce that right. So it is subject to that. Granted, if the deal falls through and the second transaction can't take place, you will obviously have to refund this person all their money. But you want to make sure that the state agent understands that this is a condition, because you shouldn't allow, they will try and claim a commission from you if they feel that the transaction was completed and later you disclose that you're not actually owner and it's subject to another transaction that you have no control over. So you do want to make these disclosures. You want to make these contracts subject to the first contract actually taking place, but you want their performance to take place simultaneously with your performance in terms of the first contract. So if you start asking questions such as which contracts do I need to use, there are certain contracts for the more advanced speculator especially, where both contracts would be drafted tailor-made to you. But if you're entry level or you're just trying to get into the game, your first contract would typically be the normal offer to purchase. You may want to mention in this offer to purchase that your intention is to on-sell, especially if you're not able to take transfer of the property without on-selling. And that's a very, very important one, because if you make this offer to the first person, the first seller, and you're not able to um, perform in terms of this offer or in terms of this agreement, you'll be in breach of this agreement. So it's also quite important to watch out and make sure that you inform everyone that it is going to be subject to you finding someone to sell this to. But naturally be careful with this, because as soon as you disclose something like that, the sellers start feeling that they should be able to sell it for a higher price. So with a lot of speculators, they have a backup plan that they will be able to take transfer of this property if the need arises, and they have a suspensive condition in order to obtain finance from a financial institution, for instance. Your second contract with the purchaser is your important contract, because there you do need to inform them that you're not an owner, that this is subject to another transaction taking place, and that although they're going to be expected to perform, they need to understand that if something happens to the first transaction, they cannot hold you liable for the second transaction, and they'll simply receive their money back. Thank you, everyone.